Be ready. 5 seconds.
These appeals are directed against the judgments and orders passed by the High Court of Delhi, dismissing the appellant's challenge to his arrest being illegal as well as his application for the grant of regular bail. Consequently, the High Court upheld the legality of the appellant's arrest and has summarily declined to exercise its concurrent jurisdiction under Section 439 of the Code of Criminal Procedure, 1973, thereby denying his prayer for regular bail. The Directorate of Enforcement arrested the appellant in the purported exercise of its power under Section 19 of the Prevention of Money Laundering Act, 2002. Subsequently, this court granted the appellant interim bail. The appellant surrendered thereafter before the jail authorities. We may hasten to add here that the question of law sought to be exercised in the ED matter is presently pending consideration before a larger bench of this court and is not relevant to the present controversy, and its particulars are included solely to ensure lucidity in the factual matrix. The special judge granted the appellant regular bail while his bail in the ED matter was pending before this court and reserved for judgment. However, the ED swiftly sought the cancellation of that bail order. The High Court stayed the operation of that order, as a result of which, the appellant continued to remain in jail. CBI moved an application before the special judge PC Act under Section 41A of the CRPC, seeking to interrogate the appellant, which was thereupon allowed. Having completed interrogation and examination, the CBI filed an application seeking permission to arrest the appellant and for the issuance of production warrants. Thereafter, the trial court allowed the CBI's application, noting that the accused was already in judicial custody in the ED matter. In the meantime, the High Court conclusively stayed the order granting regular bail to the appellant in the ED matter. Shortly thereafter, the appellant was produced before the trial court, whereupon he was arrested in the instant CBI case and a copy of the arrest memo was handed over to the appellant's counsel. On the same day, on an application moved by the CBI, the trial court remanded the appellant to police custody for 5 days. Subsequently, the trial court remanded the appellant to judicial custody. It may be noted that the investigation at that time was ongoing. Both the above stated orders of the trial court, came to be challenged by the appellant before the High Court vide a writ petition, inter alia, seeking a declaration that his arrest was illegal. When the petition was heard, the High Court issued notice to the CBI and scheduled the matter to be heard. In the interregnum, the appellant also approached the High Court under Section 439 CRPC, seeking regular bail in connection with the subject FIR. When the bail application came up for hearing, the High Court issued notice and re-notified it to be heard along with the writ petition challenging the very arrest of the appellant. Stop. The criminal appeal is allowed and the impugned judgment of the High Court to that extent is set aside. Stop. Consequently, the appellant is directed to be released on bail, upon furnishing bail bonds for a sum of rupees 10 lakh with two sureties of such like amount, to the satisfaction of the trial court. Stop.